Introduction to Human Resources Management, Chapter 3, Providing Equal Employment Opportunity in a Safe Workspace. Human resources is regulated by the government, and it's important that you understand how the government is constructed and how they operate and do their regulatory oversight. In the United States, and most of the states that are within the United States, the government is divided into three branches of government: the legislative branch, the executive branch, and the judicial branch. The legislative branch is the body of elected representatives. In the United States federal government, they consist of Congress, which is the House of Representatives, and the Senate. The House of Representatives is based on population. The Senate has 2 senators from every state. California has the largest population in the United States, and therefore they have the most representatives, but they still only have 2 senators. Massachusetts has less of a population. We have about 12 representatives, but we still have 2 senators. The idea is that it's a compromise between states with big populations and states with smaller populations. Instead of just basing it on 2 on every state and then letting everybody have equal representation, you have these 2 representative bodies within the legislative branch. We have 435 representatives and 100 senators because there are 50 states. The House will look at laws. There are proposed laws. They're called bills, these proposed laws. And if they pass and agree, they send it over to the Senate. If the Senate also agrees, they send it to the executive branch, which is the administrative branch of government. The executive in the United States is the President of the United States. The President has the authority to approve these laws or veto these laws. The legislative branch will also create administrative agencies under the authority of the Constitution. These administrative agencies, like the Internal Revenue Service, the FDA, the FTC, they all report to the executive branch. So the legislative branch creates the laws, they create the administrative agencies. The executive branch oversees the administrative agencies and how they are operated. They hire the people to fill them out. Every time there's a new president, they usually put in new people to head up these agencies. So the laws are created by the judicial branch. The administrative side of it is run by the executive. The president is also the head of the military. The president can also negotiate treaties and does other things, but it's an executive, like a chief executive officer of an organization, of a corporation. The president is the chief executive officer of the administrative branch of the government. The judicial branch includes the Supreme Court of the United States, all of the appellate courts, and all of the entry-level courts. They are basically designed to resolve disputes. So if you have a contract dispute, you can sue someone in court. They will render a decision. They also look at the laws that are passed by the legislature or actions that are taken by the executive branch and determine whether it is constitutional. The Constitution is the main source of law for all of the government. It establishes how the government is designed and how laws can be built. If you pass a law that infringes upon someone's freedom of speech, which is guaranteed in the Constitution, that would be found to be unconstitutional and struck down by the judicial branch. The reason we have 3 branches of government is we don't want any one branch of government to have all of the power and all of the control. This is a system of checks and balances. The power of one can be checked and balanced by the other. Legislative branch can create laws, but the judicial branch can make sure that they are applied appropriately. The executive can take action, but the judicial branch can look into it to find out whether it's being done on a constitutional basis. If the executive branch wants to use money to pay for something, the legislative branch has to approve it. They hold the purse strings. So that allows there to be no dictatorships, for example. You don't want the legislature to run everything because you have to have 535 people agree to something. The executive can make individual decisions when it's necessary and time limited. So the idea is that all of these pieces of the government will work together. Now, I mentioned a constitution. There are basically 4 sources of law. Number 1 is the Constitution. There are 51 constitutions in the United States. There's the federal constitution, which applies to all the states. Each state will have its own constitution. Massachusetts has its own constitution, and it's one of the oldest constitutions in the world. We also have 3 branches of government. We have the general court, which is our legislative branch. We have the executive branch, which is the governor. We also have the judicial branch, which is headed by the Supreme Judicial Court, rather than the Supreme Court, which is the federal version. So a lot of the states follow the same model, and they're all based on the constitutions. Article 1 of the Constitution establishes the legislative branch. Article 2 does the judicial or executive branch. The judicial branch is in there. A lot of the rights are done through various parts. The right to regulate commerce is in Article 1, Section 8. Right to free speech, the Fifth Amendment right not to self-incriminate, all of these other things are in the amendments to the Constitution. Those are the primary sources of law. Another source of law is statutes. Statutes are the laws that are passed by the legislative branch. Regulations are another source of law. When the legislative branch creates a law that establishes an administrative agency, like the IRS or the FCC, they will pass regulations which indicate how that should be regulated, how it should be administered. Congress can pass a law saying we should be collecting taxes, but they defer to the IRS to come up with the regulations which have very specific tax codes to tell you how much taxes you have to pay if you're a corporation or how much taxes you have to pay if you're withholding for your employees. Things of that nature, which is not appropriate to be in a statute. Regulations, however, they are an individual branch of or source of law. They are every bit as enforceable as a statute. So don't ever think, oh, this is just a regulation, it's not a statute. The regulation comes from the statute and it has the effect of law. They all come from the Constitution, however. So the Constitution gives the authority to Congress to pass a law that creates an administrative agency, and they have the authority to write regulations. All of them are sources of law, but they all stem from the Constitution. The last source of law is a little bit different. It's called common law. And this is the law that the United States inherited from our founders, Great Britain. The United Kingdom colonized North America, and in 1776, the United States declared independence. We had been using the law that was developed in England by judges. This is judge-made law by a system called precedent. If you have a dispute and you go into court, let's say you have a contract dispute, the judge will decide, yes, you had a contract, or no, you didn't have a contract, and this is what the outcome should be. Once that decision is made, that establishes precedent. So if another person came in with a similar complaint about a contract, they would look at the previous decision and then they would apply it. And if a new case came in, they would adapt and expand the law appropriately. The laws of contract, torts, which are civil wrongs, similar to crimes, but they are not enforced by the government. They are between people. Property law, a lot of this different basis of law came from judge-made law. And there are no statutes in some cases to define what that is. So you have to look at case precedent as well to determine whether or not you're doing anything that is considered legal or not. So the four sources of law are the constitutions, statutes, regulations, and the common law, and they all apply in some measure to businesses and HR. One of the statutes that was passed by the federal government involved equal opportunity employment, or the Equal Employment Opportunity Act. That basically says that everybody who is working in the United States should have an equal chance of employment regardless of whether their race, their national origin, their gender, etc. So the government regulates HRM to ensure equal employment opportunity. There is an Equal Employment Opportunity Commission that was created by statute, and they are an administrative agency that is overseen by the executive branch of the federal government. Because Massachusetts is also a government and has its own constitution, we have the Massachusetts Commission Against Discrimination, which works in tandem with the EEOC. So if you have a job complaint you think you're being discriminated against, you can file with the EEOC or with the MCAD. Oftentimes they have mechanisms where they share the complaints. Aside from the EEOC and the commission that was created, there have been other laws that have been passed by the legislative branch that include constitutional amendments, legislation, executive orders, which we'll get to in a moment, and court decisions, which are common law. The 13th Amendment abolished slavery in the United States prior to 1866. The Civil War took place between 1861 and 1865, and it was basically because the southern states wanted to preserve the institution of slavery, and the federal government didn't want them to. Because the country was expanding, new states were coming in. They would either be slave states or not slave states, and if they were admitted as non-slave states, the southern states were worried that eventually their representation in Congress would be in the minority, and they would eliminate slavery. So to avoid that from happening, they began the Civil War to be able to preserve slavery in the southern states known as the Confederate States of America. After the Confederacy lost, slavery was abolished and it was incorporated into the Constitution via amendment. It was the 13th Amendment. The only exception is if you are in prison, because you could be forced to do some labor. The 14th Amendment came out in 1868, and it was after 13th Amendment and after the Civil War, and it was to rectify some of the issues with the southern states that were still discriminating against people who had been former slaves. The 14th Amendment basically restates some of the aspects of the Fifth Amendment, and it states that if you were born in the United States, you are a citizen of the United States, so federal law applies to you. You are also a citizen of the state in which you live, so state law applies to you. Prior to the 14th Amendment, if you were in a state, the state could potentially violate your rights. But now, because the 14th Amendment says if you're a citizen of the United States as well as a state, the state cannot infringe upon your rights as a federal citizen of the United States. So the states cannot do any laws that would diminish or conflict with your rights as a United States citizen. It guarantees also that the government cannot take life, liberty, or property without due process. So there's your due process again. You have to go through the process to have any action taken against you. You have to follow a process and have the legal opportunity to put your case forward so that you can have a good decision that's made. It basically, the whole point of the 14th Amendment was to prevent states from denying equal protection and enforcing discriminatory policies within the states. So now the federal government has the ability to change state law as a result of the 14th Amendment. One thing that I should point out is that the United States, in the Constitution itself, there is a clause that states the United States Constitution is the supreme law of the land. That means that if there is a federal law or constitutional law that is passed by the federal government, the states cannot conflict with it. They cannot pass a law that says something different. However, if the federal government does not pass a law on a particular subject, the states have the freedom to pass their own laws on it. It's called the preemption doctrine. If the federal government is regulating some aspect of trade or life in general, the federal government has supremacy over this, so the states cannot have conflicting laws. If you wanted to get a tattoo in Massachusetts 20, 30 years ago, you had to go to New Hampshire to do it because New Hampshire allowed tattoos and Massachusetts didn't. Massachusetts eventually changed its laws so that tattoos are legal here as well. The federal government has no laws about tattoos, so it didn't matter. You could have some states that have tattoo parlors and some states that don't. Massachusetts does not allow the sale of fireworks. If you want to do fireworks in Massachusetts for the 4th of July, you'll have to go again to New Hampshire because New Hampshire has no prohibition against fireworks. You're technically not supposed to bring them over the state line, so that would be a problem. But that's an example of why preemption doesn't work in this case because the federal government has no laws about fireworks. So the states are free to have their own laws. However, any federal law that is in existence, the states cannot pass a law that would diminish your rights or the requirements under the federal law. We're going to talk about minimum wage in a little bit, and when we do, there is a federal minimum wage. It is $7.25. That means if you're a state, you can never have a minimum wage below $7.25 because the federal government has preempted that area of regulation. However, while you cannot give less rights under the federal government as a state, you can exceed the requirements of the federal government. So in Massachusetts, the minimum wage is $15 or even more. I think they may be trying to update it. So our minimum wage is more than twice that of the federal government, and that is okay because we are not giving less rights to someone under their federal statute that preempts minimum wage. We can exceed it, so that is legal. Just something to keep in mind. Congress also passed the Civil Rights Act, again, to rectify some of the aspects of slavery from 1861 and 1871. It basically said that all people have the same rights, whether you're white or a former slave, regardless of your national origin. 1871, it gave citizens the right to sue in federal court if they feel that they have been deprived of some civil right. That goes to the issue of jurisdiction. A court can only hear a case that it has jurisdiction or the authority to hear. This grants the federal courts the authority to hear cases about discrimination, so you can get access to the court system through the federal government for this type of a complaint. The Equal Pay Act came out in 1963. It basically stated that men and women have to be paid the same for doing the same work. It doesn't mean that women and men have to be paid the same regardless of their qualifications. If you have a man that is more qualified than a woman for the same job, that man could make more. Same applies vice versa. If a woman is more qualified for the job and is more productive or has more experience, she can make more money than the man. What it does mean, though, is if they are equally qualified, they have to make the same money. Title VII of the Civil Rights Act of 1964 also prohibits employees from discrimination on the basis of race, color, religion, sex, national origin. These are basically your protected classes. And if you are an organization that has 15 or more employees, the federal government rules do apply to that. The states can, again, have their own laws regarding this. They can exceed the federal requirements, but they cannot have less requirements or lessen the requirements of the federal law. There's also the Age Discrimination Employment Act. As noted previously, if you are the age of 40, there are certain benefits that you get as a result of this. When we had to dismiss people from the job previously, if they were over the age of 40, we had to submit any kind of a separation agreement so that they could have 2 weeks to review it with an attorney to make sure that they weren't being railroaded and there weren't any discriminatory policies being put forth. So there are certain things like that where you have to follow the policies to ensure that there isn't any age discrimination. 40 seems to be a pretty young age, but that is an age where people start to notice that they may be getting discriminated against. I've had my resume out there. I've gotten a bunch of different jobs. I did notice that the older I got fewer callbacks because the longer that you're in employment, they may think that you're getting ready to retire. They may have biases that you're not capable of doing the work. It does kick in even at the age of 40, which is typically in your 40s is when you're at your peak productivity, your capability. But there are people that do have certain stereotypes and biases, and this law is designed to help limit any type of bias that people over the age of 40 might experience. Age discrimination complaints do make up a large percentage of the complaints that are filed with the Equal Employment Opportunity Commission. The next slide shows age discrimination complaints. Again, it's not that unusual when the economy is bad and there are going to be layoffs that people who are older may feel that they are being targeted. So if you look at this chart, it does go back into the big recession from 2008, 9, 10. There had been a higher level of complaints for discrimination during that because there were a lot more layoffs that were taking place during that time. I guess the good news is over time, the complaints have been dropping pretty consistently. 1973 was the Vocational Rehabilitation Act. So that's basically for people with disabilities, it's allowing them the opportunity to have access to the job market. After the United States left the Vietnam conflict in 1973, they passed the Vietnam Era Readjustment Act. These are mostly baby boomers who are aging out of the workforce currently, so this may not come up very frequently. But if you were in service during that period of time, there are benefits that you can get. We didn't leave the war technically until 1975. We were left active combat actions, I think March of 1973. But we were technically still involved until 1975. So if you fall into that cohort, you're going to be a baby boomer. This law may apply to you and provide you some protections. There's also the Pregnancy Discrimination Act in 1978 that was passed by Congress to help protect women from being discriminated against for simply having a baby. It wasn't that uncommon 50, 100 years ago for women to be fired from the workplace if they got married, because the expectation would be if they got married, they were likely to have children. And if they were going to have children, employers thought that they weren't going to be as productive and they didn't want to deal with them. Teachers historically had been largely the domain of women. And it was not that uncommon for women when they got married to lose their teaching jobs because they would get fired. The Pregnancy Discrimination Act in 1978 tried to limit that type of sex discrimination. It also included pregnancy and health care so that if you have health insurance, it will cover pregnancy. It will not be an additional expense. That was considered to be for the public benefit. It's a public policy that it was determined by Congress to be a good idea. The Americans with Disabilities Act, otherwise known as the ADA, passed about 35 years ago. It has probably been the biggest impact for employers and for people with disabilities over the last 35 years. What it basically does is it says that if you have the capability of doing your job, you cannot be discriminated against in the workplace. And if you have a disability that can be accommodated, meaning if you are in a wheelchair, there has to be a wheelchair ramp so that you can get access to the work. If you have visual impairments, you have to have access to software or other tools that would help you read in Braille or have a speaker. If you are hearing impaired, it would have things that would close caption the material for you. It also states that the employer has to provide that accommodation. The government will not be paying for it. As long as the accommodation is reasonable, they're not going to require you to tear down your building, but they may require you to put a wheelchair ramp in there. The idea is if you have a disability, you should still be able to work if you're qualified. To be able to deny someone the opportunity to contribute to the economy simply because they have a disability that you don't want to accommodate is bad for everybody. It's also bad for business because if you have a really qualified person, you're missing out on their capability to contribute to your organization if you don't make those accommodations. From the government perspective, if you don't have a job and you are disabled, you will not have income. Therefore, you will probably fall into some type of disability subsidy that the government will have to pay for. So from the government's perspective, why would they pay for people to not work when the corporations and the companies could have a relatively minor expense and allow these people to work? Then they become a productive portion of society. They pay taxes rather than getting benefits. It's kind of considered to be a win-win for all sides. The employer will get something, capabilities that may not have even known that they were able to get. The government can reduce expenditures on programs for people with disabilities, and the people who are disabled have the opportunity to enter the workforce. So it has been a very major policy change in law since its implementation about 35 years ago. Figure 3.2 talks about the disabilities associated with the ADA and the types of complaints that are filed under the ADA as of 2021. Emotional and psychiatric issues are pretty large. Back pain, orthopedic pain, having diabetes, cancer, etc. These are all things that have requirements that there has to be a reasonable accommodation for. And if there wasn't a reasonable accommodation, employers could be in trouble for this. So you could have a complaint filed to the EEOC, the MCAD, under the ADA. Civil Rights Act of 1991 adds compensatory and punitive damages in cases of discrimination under Title VII and the ADA. Again, this is a jurisdictional issue, so it opens up the ability for people to get damages. Compensatory damages is simply what it sounds like. It's to compensate you for money that you've lost. If you lost a job and you shouldn't have because your rights under the Civil Rights Act were violated, or you didn't get a job because an accommodation wasn't made to you, you are not getting paid. And to compensate you for the lost income, they will be able to force the employer to pay you that money. Punitive damages is punishment. So compensatory damages, you can just do the math problem and say, I would have been making this much money and I didn't, so I should get that back. If the company was really egregious in their violation of it, if they intentionally did it, if it was something that the government or the courts feel that they need to make an example of, they can actually give more damages, usually money, and to have punitive damages for these people. So you could get compensatory damages, maybe $100,000 because I didn't work this year, but they could also give me another $150,000 because of the injustice that was done. Typically, in order to qualify for punitive damages, you have to have proof of a really intentional or an egregious level of disregard for the law. The Uniformed Services Rights Act applies to people who are in the armed services, particularly people who are in the reserves who may get deployed for various military actions. Their job should be waiting for them when they come back, or at least a comparable job, so that they don't lose their employment just because they have fulfilled their government service. The Genetic Information and Non-Discrimination Act forces employers to not use genetic information if they have access to it to make any decision in terms of privileges or conditions of employment. As people have more genetic information becoming available through things like Ancestry.com or just genetic testing through their doctor, through their healthcare, employers cannot use that against the employee. So if you have a genetic code that shows that you may be more liable or more likely to get some type of a disease that may be a lot of money to cover in your benefit package, this law says that the employer cannot use that against you. The Lilly Ledbetter Fair Pay Act of 2009, in Canvas, there should be a video that you can watch that describes it. They actually interviewed the person, Lilly Ledbetter. This is a woman who worked at a Goodyear tire plant for years. She was a female, and she was doing the same work of other people who were men who were getting paid more than she was. She filed a complaint under the Equal Opportunity Protection Act, but because the law at the time said that you only had 180 days to file a complaint, her case was dismissed. And what the Lilly Ledbetter law does, every time you get paid, every time you get a paycheck that is less than the other person, in this case, for a specific example, then the statute of limitations, the period of time you have to file a complaint, starts over again. Her problem was that she found out that she was getting paid less well after the date that she started getting paid less. So the court would not hear the complaint. Now, every time you get a paycheck, that is proof that you're getting paid less. So there's no statute of limitations. A statute of limitations is simply an administrative legal issue where you have a certain period of time to file a complaint. If you wait too long, you can't go there. So what the Lilly Ledbetter Act did, aside from making sure that people are paid the same, regardless of race, color, religion, sex, national origin, it did make it easier to file these complaints by changing the statute of limitation requirement. Executive orders are issued by the president, who is the leader of the executive branch, which oversees administrative issues. Executive Order 14151 was issued by President Trump in 2025, and it terminates and makes illegal all diversity, equity, and inclusion rules, accessibility mandates policies that had been in the federal government. It basically wiped out a lot of previous executive orders that had been issued by previous presidents. It is enforced by the U.S. Office of Personnel Management. It technically, because it is an executive order, it only applies to federal employees or those doing business with the federal government. However, the federal government is often a model. They're one of the largest employers, if not the largest employer in the United States. They have a couple of million people working for them. So what the federal government does have an impact because it is often emulated in the private sector. Executive Order 14170 required the federal government to base all employment decisions on merit and fitness, and states that race, color, sex, and religion and national origin should not be considered. And it does play into the recruiting and hiring practices, and that is also enforced by the U.S. Office of Personnel Management. Executive Order 14173 makes it illegal to use quotas and preferences for unrepresented groups or traditionally unrepresented groups. This is basically eliminating affirmative action, which is a policy that was designed to recruit people from underserved or previously discriminated groups from the past in order to rectify that and put them on equal standing. Again, it is enforced by the Office of Federal Contract Compliance. So these are companies that are complying or entering into contracts with the federal government, so it applies to their employees as well. So it does reach into the private sector for that reason. Executive Order 14168 makes it U.S. policy to recognize two unchangeable sexes, male and female. A lot of states may have conflicting rules for that. Again, this is an executive order. This is not a statute. So it applies to the administrative agencies that are hiring federal employees only. These are recent developments, and they may overturn certain things that have been happening before. Given the next election, they may be overturned again. So this is kind of an area that is currently in flux. The Equal Employment Opportunity Commission is responsible for looking at all of the equal employment opportunity laws. They investigate and resolve disputes about discrimination. They essentially have the power of a court. They can investigate, they can have hearings, and they can issue fines and findings as a result of their investigation. They will monitor organizations' hiring practices. They collect EEO-1 reports. These are the complaint reports that are filed. And they can decide whether laws have been violated and enter into decisions that can be filed. This is basically the first round of the legal process. If you are an employer at the wrong end of a decision made by the EEOC, you can appeal it into a federal court. So you can go to a higher level for a review. But the initial level, they do have the authority, essentially like a court. It's an administrative law agency. The types of charges that were filed with the EEOC is in this next chart. A lot of it is retaliation, where they feel like an employee has been treated improperly because they made a statement or they defended someone and they were being punished for what they did at work. The ADA for disability, race, sex, age, national origin, all of these things are parts of the types of complaints that are filed. This is just giving you a sense of the proportion of the types of complaints that are filed. There are very few genetic information complaints that are filed, but that doesn't mean that there won't be going forward, especially with the AI ability to do data mining and the potential for hacks for information about genetic information that may be available somehow. The Office of Federal Contract Compliance Procedures. As I said, the federal government is one of the largest employers that there is, but they are also one of the largest contractors. So even if they don't have employees that work for them directly, they will have access to companies that employ a lot of people, and they can establish rules and requirements for anybody that wants to contract and get money from the federal government for providing goods and services to it. They will conduct an audit that is a review of the policies and procedures to make sure that they are pursuing the goals and the affirmative action plans to the extent that they still exist under the executive orders that have been issued. The plan must include a utilization analysis, goals and timelines, and any action steps that may be required. This is to ensure that whatever policies that are out there in order to enable you to get a federal government contract that you are complying with. If you do not comply, the OFCCP could then have a finding that you're out of compliance and you could lose that contract. And in many cases, these could be multi-million-dollar lucrative deals with the federal government. In order to avoid discrimination, there are a couple of things that we need to be aware of. One of them is disparate treatment. This is when you are treating people differently, explicitly on the basis of their race, color, religion, sex, national origin, age, or disability status. Companies need to look at interview questions and management functions to ensure that they are doing things according to the rules, that any decisions that are being made are only being made on the basis of performance rather than any type of category that you may fall into in terms of demographics. When you have a bona fide occupational qualification, if you have a bona fide aspect of your job, that is perfectly allowable. So if you have a job that requires you to be able to pick up 50 pounds, you don't have to hire people that can't pick up 50 pounds, if that is something that is required. One of the things that I remember is when I was a kid, if you wanted to be a state trooper in Massachusetts, you had to be 6'2". That was one of the requirements of it. So that would be falling into more of a disparate impact, which I'll get to in a moment. But that is not a bona fide requirement. And they realized that, and they ended up dropping it. What it did is it excluded a lot of people who were perfectly capable of being a police officer. If you're 6 feet tall, you couldn't be a police officer before. They thought it would be important. They wanted to have these big, imposing people be state troopers. Then it became obvious that you could be a police officer without having to be 6'2". So that would be something that was not a bona fide qualification. The bona fide qualifications, you still need to be able to do certain things physically, but you don't need to be 6'2" to be able to do it. So you want to make sure that whatever it is that your requirements are, they are directly related to the job. What color your eyes are, what your gender is, it doesn't matter if you're able to do the core elements of the requirements of the job. So I mentioned disparate impact before. Disparate treatment is typically more explicitly or perhaps intentional. Disparate impact could be policies that you have that have the unintentional effect of discriminating against people. The example that I gave about the height requirement for the state police would be a great example of that. I'm not intending to discriminate against people, but by having that as a requirement that's not a bona fide requirement of the job, I would be excluding people that would otherwise be capable of doing the job. So the impact of having this rule for recruitment is the problem. The other thing about the 6'2" rule is you can be a woman and be a police officer and be perfectly capable of doing the job. Women typically are about 6 inches shorter than men, so that almost completely excluded any woman from being a police officer. They would not necessarily have been saying we don't want women to be police officer and we're excluding them, but the rule that they had implemented, even unintentionally, had the disparate impact of having a discriminatory effect for people that didn't meet that criteria that was not a bona fide qualification. One way that the courts can determine whether or not there is any type of bias or discrimination taking place is they employ what's known as the 4/5 rule. It's not really an official law, but it is a way that the courts do utilize a way to put context into any complaint that comes in. So it's a test that they use to determine whether disparate impact exists for hiring practices. So what they do is they look at the hiring rate of a minority group and they compare it to the hiring rate from the majority group. And if the hiring rate for the minority group is less than 4/5 or 80% of the rate of hires for the majority group, then that is evidence of potential discrimination and the case will be allowed to proceed. The next slide here gives you an example of how it works. A hotel is going to hire 100 positions. They have 300 applicants. 200 of them are African Americans. The other 100 are white. The hotel ends up hiring 40 of the black applicants and 60 of the white applicants. So what you do is you look at the rate of those hired. So for the 200 black applicants that were hired, only 40 out of 200 were hired. That's 20% of the applicants were hired. For the 60 out of the 100 white applicants, that's 60%. What you do is you compare the rate of the minority hiring, that's your numerator, that is 0.2 or 20% over 0.6 or 60%. That means that it's only 33% the rate of minority hires to the rate of majority hires. That is less than 80%, less than 4/5. Therefore, that would be an indication that there may be evidence of discrimination. So what would happen is if you have a hiring process in place and you're able to do this math yourself and you're under 80%, you could do an internal audit and find out, wow, we have the possibility here that if we get sued, this is going to continue on to potentially a jury trial and have a negative outcome for you. So this is a way that you could figure out how to not only avoid lawsuits, but how to deal with the complaints that are coming in. This is a way to identify that you could have a potential problem in your hiring practices before you actually get to a legal process where someone has filed a complaint. One of the best ways to avoid any legal ramifications of discrimination is to avoid discrimination. So you can establish your own internal EEO policy in compliance with the laws, make sure that your managers and your supervisors are aware of it, that you conduct training, define unlawful behavior, prohibit it, take action for those who are doing it, include procedures for making and investigating complaints, and provide procedures for making and investigating complaints, because if you can provide due process to your employees and rectify a complaint internally, then you don't have to worry about them filing a complaint with the EEOC and eventually potentially getting into the legal system and costing a lot of money. Do you want to mention affirmative action and reverse discrimination? Affirmative action, as I said, was a plan to address historic discrimination by hiring people from minority groups. In the 1970s, the Supreme Court had a couple of cases. One was a law student and one was a medical student. Basically, they were admitted into grad school, and the grad schools had, let's say, 100 seats for their entry class, and they set aside 20 for minority groups. That was an affirmative action process in an attempt to make sure that there was access to minority groups for admission into their grad school. A white student who did not get admitted, who claimed that he had better qualifications, sued, and it went through the Supreme Court. One of them eventually reached a decision, and the Supreme Court said that they agreed with the complainant, the white person that said that they had been discriminated against, because the quota was a problem. You cannot have a hard quota. You can consider someone's background still, but you cannot base an admission or a hiring decision only on the basis of their race. So you can't have a set-aside quota for people from a particular group. You can consider their background as one of the many things that you could consider whether someone is going to be hired for a job. But the main point is that it has to be that they're qualified for the job to be able to be hired. The reason that it's called reverse discrimination is because the white person that sued in this case said that they weren't hired on the basis of their race. So affirmative action was put in place to provide benefits and correct past injustices to people from minority groups. But this person was saying that they were being discriminated against because it went beyond what it should have. So that is something to be aware of going forward. There have been new cases. The Supreme Court had a newer case in 2023. I do have a link in the PowerPoint if you want to take a look at it. It's Students for Fair Admission versus Harvard. Under the ADA, employers are required to provide a reasonable accommodation to people with disabilities. So you have to do something that would allow an otherwise qualified individual to perform the job. Religion can be considered as well under civil rights, but disability should be considered for the ADA. The employer may be exempt from providing accommodation if it could be a significant expense or a high level of difficulty. That's the reasonable part of the accommodation. You're not required to do something that would be considered unreasonable. There's no real quality list of things that would be considered reasonable. As I mentioned, wheelchair ramps and various types of software, that's not such a big deal. That would be considered okay. But it really is up to the courts through common law, basically, to decide through case precedent what is considered appropriate or reasonable or not. The next slide just shows some variations of what types of accommodations could be done for making the facilities accessible, modifying work schedules, etc. So please take a look at the chart and read through the book. Sexual harassment is something that should also be included in your review for HR to make sure that you're not violating anybody's rights under EEO. In order to prevent sexual harassment is basically an unwelcome sexual advance, a request for sexual favor, or verbal or physical contact when submission to that conduct is a term of employment, or the submission or rejection of it is the basis for employment decisions. It can also include conduct that unreasonably interferes with the employee's work performance. Different kinds of sexual harassment include this quid pro quo, which means this for that in Latin. That is submitting to the conduct to be able to get this benefit from work. If you make a sexual advance at someone and make that conditional upon them getting a job, that would be quid pro quo. That would be explicit. But it can also be implicit, and it can create a hostile working environment where it's not quid pro quo, but there is this sexual harassment that creates what's known as a hostile work environment, where it creates stress. You feel uncomfortable in your job. If an employer is found to have allowed a hostile work environment to exist, then the employee will have grounds to take legal action against them. If you are a manager and you know that you've got a complaint, you need to investigate that immediately, because if you don't investigate it and take action and allow it to persist, you could be found to have a hostile work environment. And that is a legal requirement to get into the court system. So you don't want to let these things linger, let them fester and turn into bigger issues, because if you are found to have a hostile work environment, it opens the door for legal liability. Some of the ways that you can prevent sexual harassment: have a good policy, enforce it, take action if it's taking place, make sure people understand what sexual harassment is, what it looks like, and how to avoid it, and how to report it if that is happening. You want to make sure, again, that you act promptly to discipline those that are involved so that you can eliminate the possibility of being found to have a hostile work environment. Diversity is something of value for a company. It can be kind of a political issue, but the idea is diversity of ideas is also important. If you have people from different backgrounds, they're going to bring a lot of different things to the table. And if you have more options based on input from people, you can come up with better solutions. So diversity, if it's well managed, and that's the key, can be a real benefit to people and a company. Particularly if you are a company that is providing services and products to a very diverse marketplace. If you only have one type of people working for you, it's going to be hard for you to convey the message and the services and the products that you have to the people that you're trying to market yourself to. The best way to market to those people is to hire people from that group so that they understand what they're looking for, and it can help you with your marketing. So diverse workforce can be part of your competitive advantage. If you have diversity in leadership, the same as diversity in your employees, that can be an important element. Some organizations within legal constraints can practice affirmative action. You can consider someone's background. It may not be a bona fide requirement of the job, but it is something that can be considered. Another thing that you want to consider is the Occupational Safety and Health Act, otherwise known as OSHA. OSHA was established, and it creates inspections for workplaces to make sure that the workplace is safe and that health hazards have been minimized to the extent that are possible. If a company violates the requirements of OSHA, they could be fined for violations. And it can cost them more money, too, because the rate that they have to pay for things like workers' comp because of injuries that happened can be higher levels. So that is something that can end up costing you money in the long run. OSHA has a general duty clause. It basically states that every employer has a general duty to furnish an employee a place of work that is free from recognized hazards. That doesn't mean every hazard, something that pops up that you didn't expect, but if it's a recognized hazard, you have to be free from that and take actions to mitigate any problems that could result from it to avoid death or serious injury or harm. The specific duties that you have to keep track of all the records of work-related injuries and illnesses, and you also have to post an annual summary of these records from February 1st to April 30th the following year so that the employees are aware whether or not you're in compliance with it. OSHA also requires that you post on the wall in break rooms and other places and submit information to your employees about the requirements of OSHA so that they know that they have the right to call OSHA to come in and have their workplace inspected. The next slide is an example of the Form 300A, so it's a summary of work-related injuries and performances for companies, the number of cases, the number of days people were out sick. That's just a way to track how well you are complying with keeping your workplace safe. Employees under OSHA have the right to have a federal government officer come in and do an inspection. They can have a representative present at the inspection. They can have dangerous substances identified. Sometimes you may work with a place that has chemicals and other hazardous items. They need to be identified, and mitigating procedures have to be implemented to ensure that they're not presenting a risk of undue harm to their employees. Employees also have the right to be promptly informed about exposure to hazards and be given access to accurate records regarding that exposure so they can take action to mitigate any problems that could have arisen. The employer violations also have to be posted at the workplace. So if you are an employer and OSHA comes in and cites you for any type of violations, that's going to go up on the wall and it's going to be public for everybody to know. The next slide has an example of what has to be posted at the workplace regarding health safety requirements of OSHA. They are the ones that go out there, and it works best when people have the idea that they exist, and employers have to be aware that their employees could be calling to be able to comply. So again, the best way to avoid this type of stuff is to understand that these are the requirements and create policies and programs to be able to adhere to them so that you don't get to the point where the government is coming in and fining you and putting up citations that you have to publicize to all of your employees, which could diminish your reputation among your employees and among potential employees in the future. Figure 3.7 is a graph that shows the number of times per 100 full-time workers there has been a complaint regarding an injury or an illness on the workplace. And it has been something that has been dropping fairly consistently over time, which is good news. Hopefully it's because companies have recognized that these are issues that have to be addressed. The other thing is, if you are hiring people to work for you, you don't want to have a workplace-oriented lawsuit against you. You don't want to have OSHA coming in, but you also don't want people to be missing work. You're paying them to work for you. The more time that they're out because they've been injured on the job because of something that you could have prevented makes you less efficient. So there is a business argument. Aside from the requirements and the ramifications of violating the law, there's a good business reason to go ahead and make sure that the workplace is as safe as possible. When OSHA does an inspection, the compliance officer will review all of the company's records that the company is required to keep. They will walk around the premises and have access to various areas. They will interview employees, and they will conduct a closing conference with the employer and note any violations that have taken place. The employers have a particular period of time to correct violations, and they may have to pay fines, especially if they're repeat violations. So employee rights under OSHA is that you have the right to file a complaint and request an inspection. They also have the right to receive information about the materials on the job. The employee responsibilities is that they have to follow the rules. You can't take the benefit of the rights that they give you without following through on it. So there are rules that they have to follow as well in order to get the benefit of the rights. They also have to report any dangerous activities in the workplace in order to make sure that the workplace is kept safe. So the impact of the Occupational Health and Safety Act, it has raised the level of awareness for occupational safety. There has been, as you noted in that graph, there has been a consistent decline over time. Going back 100 years, the rate of injuries was much higher than it has been in recent times. So part of that is due to the fact that we are more of a service-oriented economy. There's a lot less people that are going out there doing dangerous physical work. But a lot of it is also due to the fact that OSHA is working and the companies realize that there is a benefit to be able to comply with them. There has been an increase in claims of retaliation if you file an injury report. So again, if you call OSHA, you have the right to do that. But if your company then takes action, they give you a bad assignment or they write you up or they lay you off or something, that could be retaliation. So you have to be aware of that. There should be no retaliation. Employees have the right to ask for an OSHA inspection. You cannot retaliate against them because they exercise their rights under the law. One way that you can cut down on lost time and money because of employee injuries and to help minimize the potential exposure that you have to violations under OSHA is to conduct an internal hazard assessment. You do your own audit. Every job you break down into the basic elements, you figure out whether that's the potential for harm, and you take actions to be able to minimize the potential for harm. You communicate the job hazards, you train people effectively, you communicate at a level that the audience will understand, you give them the needs and training by age group because there could be different issues that are related to it because of their capabilities. You also want to reinforce safe practices, make sure that there's a safety incentive program. You may have worked at a place that said it's been X number of days since the last injury. They are publicizing that. They are trying to make sure that people are aware of it. Reward workers for commitment to safety goals. You can give them benefits and incentives in their pay. Recognize them for doing the right thing. You can start with smaller goals and expand to long-term goals. And when you identify problems, you need to take action to fix them. Target jobs or hazards that are most likely to cause injuries. They can be your primary focus. You should do all of the jobs because even if you're just typing on a computer, you could have repetitive stress injuries and end up with carpal tunnel syndrome. Every job has the potential, but you should definitely focus at the ones that are most likely to result in major injuries. If you are a company that operates internationally, you have to understand that every country has their own version of OSHA, or maybe not really that many requirements at all. Cultural differences can also make it difficult to make sure that you're applying the same standards from all of your offices depending on where they're located. The main thing is that training and supervision, regardless of where the company is doing business, you need to make sure that the company's procedures and policies are applied everywhere, and you have to use the cultural knowledge if it may be different, and make sure that you're complying with the various rules for each jurisdiction in which you're operating. The next few slides are just summaries, so that'll take care of Chapter 3. We'll be doing Chapter 4 next.